Hello, everyone, and welcome to another immigrationquestion.com webinar session. Today, we will discuss overcoming U.S. visa denials, understanding your options. I'm Andrew, and I will be your host for this session. Getting your visa denied can be devastating, confusing, and sometimes stressful, but it does not have to be the end of the road, and there are available options you can explore. So, to help us simplify the process and educate us on available options is a very special guest. He's an immigration attorney from Dallas, Texas, and he has decades in experience as an immigration lawyer. And I would just like you all to take a second to acknowledge and welcome Sonu Lal.
Thank you, Andrew. Thank you for the kind introduction, and hello, everyone.
Thank you for being here, Sonu. To our audience streaming on various platforms, as always, it's about to get exciting. So grab your notepads and pens, and let's dive right in. Mr. Lal, to kick things off, can you walk us through some of the common reasons why the U.S. visas get denied, and what should applicants be aware of to avoid making these mistakes?
Sure. So I will give you a few instances, few cases that I've dealt with, which will give a brief idea why the visas gets denied and what can you do about it. I'll start with number one. The most common visa denial reason is Section 214B of Immigration Nationality Act. Whenever you're applying for a non-immigrant visa, specifically what is called B1, B2, or a visitor's visa, it's a big issue for this particular visa. You have to show to the consular officer that you do not have an immigrant intent. How do you prove that? There are several ways that you can show to the consular officer that you do not have an immigrant intent to immigrate to the United States. Let's say you are applying for a visitor visa to visit your family. Let's say your child is studying in the U.S. on an F1 visa, and you want to visit your child. To satisfy the consular officer that you do not intend to immigrate to the U.S., you would have to show that you are employed in your country and other factors that you can show to the consular officer, that you have sufficient funds and you have attached to your country, meaning you are a property owner, you have a job already, or you have established business in your country, so that why would you emigrate to the United States if you are already established there? So this is a general sense that you can give to the consular officer who is interviewing you. That's about one visa type. Another visa type is F1 student visa, where we see denial and then the students come to us for help. What can they do? First of all, many people have this misconception that if their visa gets denied one time, they have to wait for a certain duration to be able to reapply. There's no such thing. You can reapply as soon as you want it, provided you have overcome the reason for that denial. And in general, in F1 student visa context, the reason normally that we see is you were not able to satisfy the consular officer that you have sufficient funds available to you to be able to afford an education and lodging in the US. If you were denied for that particular reason, generally that's the case. You can overcome that reasoning by showing sufficient funds available to you. Now, when you're showing sufficient fund, it need not be in your bank account. It need not be even in your parents' bank account. Someone else, some family friend or a relative can be a sponsor. They can show their income proof. They can show funds in their bank account and saying that they are willing to sponsor you. Another documentation that you can show to the consular officer as a bank loan. That even though your parents or yourself do not have sufficient funds, but there is a bank who's willing to give you an education loan, and then you can afford that US education. These are the two most common visas that get denied, and we are contacted by prospective clients to overcome these visa denials. And this is how you can overcome these denials. And over the course of this webinar, we can probably discuss more visa denials in other kind of cases.
Okay. Thank you. I really appreciate that answer, and that sets us off on the right foot. Now, let's say that someone does receive a denial. What options do they have at that point? Could you please explain the appeal process and what steps they can take to challenge the decision?
So let's say if somebody's visa gets denied and they come to us, first thing I want to figure out what happened with them during the interview. What was the line of questioning from the counselor officer, and where was the counselor officer dissatisfied with the answer? And in most non-immigrant cases, top reasons for denial is you were not able to show that you do not have intent to immigrate to the US. Meaning the reason of the denial was Section 214B, which is most generic, most common reason for most visa denials. Meaning the officer is thinking that the reason that you are applying for a visa is that you don't want to come back from the US. If that's a reason, what you can do is you can reapply the visa. An immigration attorney can prepare you what kind of proper answering you can give to the consular officer to convince the officer that you do not intend to immigrate to the United States. That's why we normally recommend, if you are going to apply for a visa, consult an immigration attorney. Very, very important.
Awesome. Thank you very much. Um, could you please explain? You spoke about the F1 specifically. Um, what are some other common denials that we get in just other visa types, like your employment visas, your asylum visas, your marriage visas? I mean, we can take these as we go, and we can talk about them later. But just a broad stroke as to like why people often get a denial when they are sufficiently represented or prepared to immigrate.
So let's talk about the employment-based visa. The most common of those employment-based visas is the H-1B visa. So first, understand the H-1B visa process. The other visa types like B-1 visa or F-1 visa, there is no USCIS involved in the visa process. You directly apply the visa at the US consulate in your country. But for H-1B, which is a work visa, it is a two-step process. Number one, first the employer files the H-1B petition with the USCIS in the United States. Once that gets approved, the second step is you apply for a visa. Let's assume in our example, the H-1B has already been approved and you are going to apply the H-1B visa at the US consulate. And now you apply for the visa, you went for the interview, the visa was not issued, you came back home, you're checking your status online, it says visa has been refused. Most people think that visa has been refused means it has been denied, you will not get the visa. It doesn't mean that. In most instances, when it says visa is refused, what it means is they are doing certain kind of background checks and they put your case in what is called 221G of the Immigration Nationality Act. It means your case has been put through certain kind of administrative processing. The reasoning can be anything, but in generally, what they are doing is they are doing background check on the application, which has already been approved by USCIS. What happens? The consulate officer want to revalidate, re-verify certain facts in that H-1B petition. In most cases, the consular officer sends an email to the employer verifying all the information, whether the employer is legit or not, whether they want to bring this employer to the US or not. Another layer in this whole scenario where the H-1B worker is going to work at a third party site. Let's say I am the employer, I am sponsoring this employee to work for my company, but I am going to have this employee to work for my client on a particular site, not on my office. So in that case, the client is also involved in that H-1B petition. In that case, the consular officer in sometimes might also want to reach out to that particular client whether they are expecting this particular employee as my employee at their offices or not. And they issue the visa once they get the positive response from the employer, from the client. During this entire process, which might take frustratingly long time, maybe couple of weeks or sometimes couple of months, only once the consulate verifies all this information, you will see that your status has been updated. Either the visa has been issued or they would want to schedule another interview for you. But eventually, if everything is positive, you will get the visa.
Now, thank you for that answer. I have heard that a waiver is sometimes applicable when to kind of combat ineligibility. Could you please shed a little bit more light on how waivers are effective and when we can use them?
Correct. So it is called a 212D non-immigrant waiver. If you have been found or denied a visa and you have been found inadmissible for a certain ground, sorry, let's say uh, in your previous visa application, while either in the US or at the consulate, you kind of misrepresented certain facts in your visa application. And then either US immigration or the consular officer figure that out, that you are misrepresenting certain facts, they denied your visa and they are saying that you are inadmissible to US for at least 5 years. So how do you overcome that? You overcome that by applying for this waiver called 212T non-immigrant waiver. This is a very generalized waiver. There is no form available. There is no particular process to be able to apply for this waiver. But in most instances, what you can do is you can reapply for that particular visa that you were denied for. At the same time, you can prepare that waiver application or waiver packet. Essentially, what that waiver says that to be readmitting to US, it will not harm to the United States and it will be in the interest of United States. But in general sense, let's say you are denied a visa, but now you have an employer in the US and you are going to work for that employer's very important project, maybe cancer research, maybe some big IT project. And if you can document that in the sense that you can provide a letter from that employer or for that particular client that you will be working for, you can include those documentation in your waiver packet and try to convince that officer that yes, I made a mistake. I'm sorry about it. Please recommend this waiver so that I can go and work for that particular client or for that particular employer. This is how you can overcome that previous visa denial and founding of that inadmissibility issue on you.
Thank you so much. I appreciate that answer and all your time so far. A real quick question or message to our audience across all the platforms. If you have any questions, please feel free to post those in the chat, and we will pick from those questions to answer in our live Q&A portion of this. We will try to answer as many questions as we can. Yeah, go ahead and put those in now so that we have a chance to look them over. Mr. Lal, can we talk about alternative options? Like sometimes denial might just be the visa category wasn't the right fit. What are some alternative visa options people can explore if their application is denied?
It's a very good question. I'll answer in particular case scenario that I have dealt with. Let's say you applied for a B1 or F1 visa. It gets denied for any reason. Later on, you get married to someone who is already in the US on a work visa, let's say on H1B. Now, what you can do is you need not apply for an F1 visa. Rather, you can apply for a H4 visa, which has a almost 100% approval rate for that particular visa. And with that visa, what you can do is you can easily get that visa H4 And when you are in the US, you can do whatever you wanted to do on F1, meaning if you wanted to study in the US on F1, you can do the same thing on H4 also. And later on, you can also change your status from H4 to another visa that you want to. Most commonly, you would want to change your status either to F1, because through F1 you can get a work authorization, or if you can get a job, you can switch to H1B also. This is how you strategize your visa denials.
Great. Thank you. Before we go into the live Q&A session, what would you say are the best practices for someone applying for a visa? As in, how can applicants strengthen their application, their portfolio, and improve their chances of approval? Just to be in the best shape to really get success upon applying for that visa rather than have to deal with the frustration of a denial.
I do a lot of consultation with these people whose visas got denied. Normally, I say if you are going to apply for a visa, consult with an immigration attorney. An immigration attorney can let you know what are the weaknesses and strengths of your visa application. And if there are weaknesses, an attorney or an immigration professional can guide you how to strengthen those weak parts of your visa application. And even if you are not consulting an immigration attorney, just go through your basic facts in your visa application. Make sure that the information that you are providing to immigration is correct. I'll give you an example where people make mistakes. If you are filling in the DS 160 form wherein you apply for the visa, you are filling in all the details about your education and work experience. Sometimes people by mistake miss out relevant portion or relevant dates or relevant employer detail. Maybe they have worked for 3, 4 employers and they missed maybe putting in one employer's information. Later on, we have seen either at the visa application or later, even when they are in the US going through their green card process, those small things becomes very big. Immigration comes back saying that you misrepresented when you applied for a visa so many years ago. That becomes a problem. So be careful when you are filling out that form DS 160.
Great, thank you. Real quickly, whether you're just tuning in or have been with us from the start, this is immigrationquestion.com's live streaming program. Immigrationquestion.com is transforming how immigrants connect with experienced immigration attorneys. Ask your questions for free, and we will connect you with a verified attorney on our platform. We'd like to call it the meeting place for immigrants and attorneys alike. For attorneys, IMQ is your chance to grow your practice significantly. Sign up today and start boosting your firm's growth. Before we get into the Q&A, Mr. Lal, do you have a moment to just tell us about your experience using immigrationquestion.com?
Well, my experience has been great. It's a great platform if anyone to be on it. I've been as a guest on this platform a couple of times. I think it brings you kind of market yourself in a very well format. It's a very great platform.
Great. Thank you so much. Everybody, please keep on posting their questions. Our guests will be answering them shortly. We'll open the floor now for the question to answer. Please feel free to type your questions into the chat box, and we'll try to address as many as possible. Our first question comes from Akio K. My application for an E2 investor visa was denied because the officer said the investment wasn't substantial. What criteria should I focus on to make my case stronger for reapplication?
It's a great question, a very relevant one with respect to E2 visa. In my career, I've filed so many of E2 visas, and I rarely see a denial for E2 visa. If it has been properly filed, there's a very high chance it will be approved. In any case, if this particular case got denied and the issue was a substantial investment, first understand for E2 visa purposes, what is substantial investment? There is no magical figure that says that this is a substantial investment. Every case will have particular requirement, meaning the substantial investment would depend on a kind of business that you are investing in. Let's say you are investing in a small business such as a small, maybe a tech firm or an IT consulting firm. $100,000 would be a great or a substantial investment for such kind of business. On the other hand, let's say you are opening a big hotel, $100,000 would not be a substantial investment for that particular kind of business. So substantial investment would differ case to case and business to business. Now, for this particular question, if your case got denied and the officer had an issue with your investment being not substantial, what you can do is you can probably invest more money in that business and amend your business plan and supporting documents accordingly, showing that the investment is substantial, and you can reapply for this E2 visa application. I'm pretty confident if you can overcome that issue with that substantial investment, it should get approved.
Thank you so much. I'm going to wait for the next question to post. And here we have one from Aisha Mohammed. I am enjoying the webinar. My question is around my student visa. I applied for an F1 student visa, but got denied because the consular office said I might not return home after my studies. What options do I have to appeal or reapply?
Unfortunately, there is a legal concept called consular non-reviewability, which means you cannot appeal the consular officer's decision. Only option you have is to reapply. Now, to reapply, maybe I would advise you to consult an immigration attorney. If you don't do it, just go through the objections or the issues that the consular officer had with your questioning, meaning if the officer was not convinced that you do not have that non-immigrant intent, try to convince the officer next time when you go for the interview that you do not have an immigrant intent to immigrate to the United States. Try to focus that after studying whatever you're going to study in the US, you have a great career in your home country within that particular field. If you can convince that officer, then maybe you can get the visa. Just try to convince the officer based on whatever I just suggested.
Okay, great. Thank you. Our next question comes from Juan Cortez. Hello, my name is Juan. Thank you for the webinar. My tourist visa B1/B2 was denied 2 times, even when I showed my money and proof that I will come back to Spain. What can I do now, and how can I make my case better?
So if you have already been denied 2 times, it doesn't mean you cannot apply again. You can still apply, but I would suggest before you apply again, travel internationally to 1 or 2 countries and then maybe have more funds in your bank account next time you go for the interview and then try again. But again, I would repeat, if you have already been denied 2 times, your case is already been showing some weaknesses, I would suggest travel to a couple of more countries and then apply again. And then let's see what happens.
Now, specifically for Juan, just because I'm noticing that he's coming from Spain and that is an EU country, should he travel outside of the EU, perhaps England or Morocco, someplace that is not just the EU?
I would say two things on this. If somebody's applying, somebody's from Spain or Europe, and they're applying for a B1, B2 visa, I would assume their ESTA has already been denied. That's why they're applying for a B1, B2 visa. That's my assumption. Second question is, yes, I would say travel outside of EU region and then apply.
Okay, thank you very much. Our next question comes from Ravi Shaveen. I'm applying for an H-1B visa, but they denied me because they said I did not have enough proof about my job sponsors. What papers do I need to show next time? Thank you.
So Typically, if the counselor is denying an H-1B visa, before denying, they issue what is called 221G notice. In that notice, they will list what documents they want to see from you or either from your employer. In my experience, and I've filed thousands of those H-1B cases, H-1B visa gets denied only when there are issues in most cases from the employer side, meaning the employer does not have that particular project that you'll be working on, or there are some fraudulent or misrepresentation issues with your H-1B application. In very rare instances, I see that there are issues from the visa applicants. So if the visa in this case got denied, I would assume generally the issues was with related to the employer. If that's the case, what you can do is find a new employer who can file a new H-1B petition for you. Once that H-1B petition gets approved, you can apply for a new H-1B visa based on that new H-1B approval. If the consular officer has already denied H-1B visa, they are not going to issue you H-1B visa based on the same H-1B petition.
Thank you. I'm seeing actually up in our chat at the moment, we have a Mike Applegate coming from YouTube, and he asked, my wife just got 221G refusal for additional evidence, category IR1. If she gets denied, can we appeal?
So if you have been issued 221G, generally the consular officer actually wants to approve your case. It's just that they are not convinced at this time with your application. So in the 221G, if they have requested certain kind of documentation or information, you provide them that information or documentation. If they have not requested any kind of documentation, they just issue 221G notice, then I would say you just wait. They are probably doing their background checks. If the background checks comes positive, they will issue you the visa. But to answer that question particularly, as I said before also, there's a concept called consular non-reviewability, meaning if the visa gets denied, you cannot appeal it. You just have to refile your case.
Okay, thank you. I hope that helps, Mike. We have another question from Maria. Hello, my name is Maria. I applied for a K-1 fiance visa, but it was denied due to lack of evidence of a bona fide relationship. We want to reapply. Can you please tell me how to avoid another denial?
So for K-1 visa, understand the basic requirements. That the petitioner should be a US citizen and that you have met your fiance within last 1 year. And you have to document that meeting and that your intention that you intend to marry this person and you want to spend the rest of your life with this person. Because immigration, US immigration takes marriage fraud very, very seriously. And they take this marriage-based green card application as well as K-1 visa application very, very seriously. So next time when you apply again, make sure you provide all those documentation which shows the bona fide of your relationship. You can provide all the communication that you are having either over the text, emails. You can maybe take PDF copies, print, and provide those documentation. If you have met in the last 1 year, you can provide maybe your air tickets, your hotel, time you spent together, a lot of pictures together. That's how you prove that you have a bona fide relationship and you intend to marry this person.
Great, thank you very much. Well, that is all the time we have for today. I want to thank all of you for joining us. A special thank you to our guest speaker, Sonu Lal, for sharing his time and expertise, and we cannot wait to have you back on another show. We always appreciate all of your insight and experience. So everybody take a second to thank, digitally, give some thumbs up and claps.
Thank you. Thanks for having me, Andrew. Thank you. It was a pleasure
and
to be
if you are It was great to speak with you. And if you are in the Dallas area, in the Flower Mound area specifically, go see Mr. Sonu Lal. He is an expert immigration attorney with a ton of experience. Um, we hope this webinar answered some of your key questions on overcoming U.S. visa denials and understanding your options. Visit our website, immigrationquestion.com, to connect with experienced immigration attorneys who can guide you through your unique situation. If you missed any part of this session or would love to listen again, catch us on Spotify. This live stream is being recorded and will be live for listening on Spotify. Simply search Borderless Talk by immigrationquestion.com and listen to today's sessions and previous ones as well. Our next session will be next Friday, as it is always, Friday, 2:30 Eastern Time. And we will have another seasoned attorney doing another immigration-based topic. And yeah, it's always informative, and we always have a very experienced immigration attorney who can answer almost all of your questions as long as we have time to do them. And just one more time, thank you everybody for coming and listening and posting your questions and sharing your time, and especially to Sonu Lal. Until then, stay informed and empowered in your immigration journey, and everybody have a great day and a great weekend.